No, not Michael Arnold here again, and Bernard the Barrister there. Hello! And this is the second part of Where Have All the Attorneys Gone? In part one, I told you the story of how it happened that there are no attorneys, in the sense of lawyers, left in England and Wales anymore. They're now called solicitors. And is it really necessary to have two professions, though? Most people, I wouldn't say most people, a lot of people don't know that actually you can come straight to a barrister now. And when I say now, that has been going on since 2004, nearly 20 years now. Because this video is being recorded in January 2023. So for nearly 20 years, you have been able to come directly to a barrister. But a lot of people still don't realize that. And they go through a solicitor in order to instruct a barrister. I have to declare an interest here because I am a barrister. In certain cases, yes, it probably is a good idea to have two lawyers involved, but not in every case by any means. And of course, it's one of the reasons for the very high fees involved in litigation in this jurisdiction, England and Wales. I'm not now talking about Scotland. And unfortunately, there are no very precise rules about how much can be charged, or even how a bill has to be presented. Solicitors do not have to give you a detailed bill. How can that be right? How can that be right? You can ask for a detailed bill from any tradesman, and they have to give it to you, because otherwise it looks as though they are charging for things that they haven't done, or they haven't assessed it properly. But with solicitors, they usually don't give you an itemized bill, and they don't have to. I'm reading now from the Law Society website, which is the website of the organization of the solicitor's profession. If your case went to court, it says here, your solicitor will give you either a detailed breakdown bill, well, that's fine, or a summary bill, otherwise called a gross sum bill. If your case went to court and you only receive a summary bill, I'm still reading from the website, you can ask your solicitor for a detailed breakdown bill. But you need to ask for it within 3 months of getting the summary bill. The detailed bill will replace the original summary bill. Good, but you've got only 3 months to do that. And here we have a very surprising remark. If your solicitor is suing you for an unpaid bill, they do not have to give you a detailed version. What? They are suing you, so how can they prove that you owe them what they say you owe them? Surely this can't be right. But this is the situation today, in the 21st century. What about non-contentious? Because, of course, though up to now we've been talking about contentious bills in contentious cases, in other words, cases that have gone to court, where there's been a dispute and it's gone to court, but a lot of the work done by solicitors is, of course, non-contentious, like Conveyancing, for example, which is a very big part of a lot of solicitor firms, arranging for sale or purchase of property, and many other areas of law as well, which are non-contentious. They're not involving court at all. And here's what it says about that in the Law Society, on the Law Society website. If the work did not involve a court case, your solicitor will give you a summary bill, sometimes called a gross sum bill. Again, you can ask your solicitor for a more detailed bill, but they do not have to provide one. Let me read that again. You can ask your solicitor for a more detailed bill, but they do not have to provide one. Really? How can that be right? It then goes on to say, if you're unhappy with your bill, you can complain about it, but that involves a whole new application to the court. So, is that really a satisfactory situation? I don't think so. And I have previously talked about the German system. This is for litigation, for contentious cases. In Germany, as in this jurisdiction, England and Wales, the loser pays the winner's costs. In that respect, it's the same. But that's where the similarity ends. Because in Germany, the costs that a lawyer can charge are controlled by law. They're laid down in very great detail in the equivalent of an act of parliament, legislation passed by the German parliament. Why don't we have anything like that here? Long overdue. And the beauty of the German system, which I've actually mentioned in a previous video as well, is that it works in favor of ordinary people. I've never seen a German lawyer slumming it. I don't believe there are many German lawyers who are below the breadline, if any. But the system of fees is regulated by law. And it worked on a very simple and very fair basis of inverse proportion. I've discussed this before, but I'm going to mention it again because I think it's so important. Inverse proportion, meaning that as the value of the claim goes up, so the amount that a lawyer can charge for his services, the percentage of that claim that a lawyer can charge goes down. That makes sense because there's a certain basic amount of work involved in any case, however small. So with the smallest case in Germany, let's say a case where the claim is only for 500 euros, the lawyer's fees can be 45 euros, which is 9%, which is a high percentage, although it's a small amount of money. But as the value of the claim increases, so the percentage, the proportion of that claim that can be charged by a lawyer goes down until it reaches 2%. So for a case of claim worth 500,000 euros, let's say, the maximum that a lawyer in Germany could charge would be 2% of that, 10,000, which is quite reasonable. There's no such restriction here. Now, I must add that there is another little wrinkle in Germany that, yes, a lawyer can have a private arrangement with his client to pay more than the statutory amount. Yes, you can. That can happen. But if it happens and that client wins the case, that extra amount above the statutory limit that the lawyer has arranged by contract with his client cannot be claimed if that client wins. The other party, the losing party, will not have to pay that extra amount. The losing party will only have to pay the statutory amount. In other words, they'll know exactly how much they're in for, which is far fairer. Why has our Parliament, which really means the government, not stepped in to regulate these things? Not just this is important enough. Fees, charges, legal costs, but the very law itself. That's why I've often said, don't blame the judges, because the judges have filled a vacuum caused by the failure of Parliament to do what it's meant to do, which is to make law. As a result, the law is very uncertain. Another reason, another very important reason, why costs are so high here, because if you lose in one court, you think, well, the law is so uncertain, the lawyers all disagree, the judges disagree, well, go on appeal, see if you do better the next time. You need permission to go on appeal, and that's another court case. It's just not working properly at all. Government, Parliament, literally Parliament, but that really means the government, must step up to the plate and do its duty by making law and regulating the whole system, which is simply not being done. More next time. All right.